Good morning, thanks very much. I'm generally a really loud speaker, so if I'm making too much noise, someone please let me know. My boss, who's David Salim, actually isn't here today, so it will just be me. And I hope this is a little bit interesting. I know the last few days of talks have been great, so apologies for the more regulatory talk. I'm here to talk about this, I suppose some of the problems that we are definitely seeing in the exploration space. The way that I like to do these kind of talks is to give an overview of, if you are in this position, this is what you're going to expect, to give you a heads up, I suppose. All right. So general disclaimer. So just further on the actual topic today of what I'm speaking about, I've spoken about the approvals process generally multiple times. I've spoken about various aspects of the process multiple times and land access, so I kind of wanted to do something a bit different to keep it interesting. So to that end, I won't be bringing up land access or how to draft approvals or how to deal with security deposits, but if you want to have a chat, I love to talk, so come up afterwards. What I want to focus on is some of these potential unexpected obstacles which can come up. So the approvals process in general looks like this, and I think overall people, like industry in general, have been really good talking about, you know, where does this start and where does this end? And there's been, I suppose, not enough focus put on what happens in the middle when you know you need a particular type of approval and actually getting and being able to execute that approval. And there's a whole bunch of issues that can come up in the process, and I'm sure there's many people in this room who have dealt with many of these issues before, whether it's actually getting an approval to drill or whether it's dealing with landholders or whether it's dealing with other sorts of environmental issues. Today, what I wanted to talk about is actually focus on three particular, very real examples, which we've been getting questions about for the last 12 months, and it's just increasingly common to kind of give an overview of, I suppose, what the situation is and what to expect if they're encountered. So, the first issue, landholder-specific conditions. What to expect when your landholder is the National Parks and Wildlife Service. So overall, it's going to be fairly rare to have the NPWS be a landholder, because most land that's under their control you can't explore or mine in due to legal requirements. There are a few exceptions to this rule, which can include certain types of reserve lands, such as state conservation areas or other reserves where you have tenure that actually predates that reserve. There is another suite of land which is held by the NPWS, which actually isn't reserved, it's just held for future purposes, where they'll be your landholder as well. And these are referred to as Part 11 lands, and might be a bit more difficult to actually, I suppose, find unless you're going through title searches and having a look at who actually owns land or controls it. So in the event that you're interested in doing some sort of accessible or higher impact activity, like say drilling for example, and you need to go to the NPWS in order to get on that land to do that work, this is kind of what you should expect. So your first point will be consultation with the NPWS to discuss what you're planning on doing and really getting that in principle support for what you're doing. That can take some time in itself. Second point is to prepare a review of environmental factors, which is something the NPWS will expect you to complete up front. That should be a series of studies into particular environmental factors, which can involve a whole bunch of specialists. Once that's been lodged and goes in for assessment, you'll generally have 40 calendar days for that review of environmental factors to be determined. It's important to keep in mind that throughout those 40 calendar days, at any point in time, the NPWS may come back to you and ask for further information. And as soon as that happens, it will push out the timeframes even further, because you yourself need to provide that information, which generally has other parties involved, and actually give it back to the NPWS for further assessment. So assuming you've got through all of that and you actually get to a determination on your review of environmental factors, you then obtain a land access arrangement with the National Parks and Wildlife Service. In the accessible prospecting operation space, your environmental assessment is to come before they will negotiate a land access arrangement with you. Once you've gone through that process, there's generally a whole suite of conditions which might apply to your particular access arrangement. It's common to see requirements for environmental management plans or an extra bond and the like, but really depends on where you're working and the nature of your activities. It's important to keep in mind as well, on top of all of that, that's just the process of dealing with the National Parks and Wildlife Service, who are a different government body in itself. You still need your approval under the Mining Act through the Resources Regulator. So as a whole, with your preparing your environmental assessment, your determination, your possible request for further information, and then your standard approval on top, it can take some time. Okay, so if you're interested in doing lower impact activities or exempt activities, it's generally an easier process but still takes time. You generally won't need a review of environmental factors, but it can be requested at any particular point in time for policy reasons of the Npws. They might request other studies be done before you access the land, and that's even to walk on it, to do any sort of mapping or to even use an access track. But again, that should be discussed in a consultation process with them. And you still need your land access arrangement. So in summary about that particular issue, I suppose the take-home message, if you ever have to deal with the Npws because they are your landholder, be aware of the multiple approvals you're likely to need and how long that's going to take and the possible third parties you might need to get involved. Beware of costs. So in addition to all the costs for any studies they might be asking or having heritage specialists come out and actually look at the land and conduct heritage surveys, on top of that, you've got pretty expensive compensation for the Npws. And again, beware of time. So to that end, we recommend starting this process sooner rather than later if you're interested in going on there eventually. Okay, to my second point, issue 2, I've identified a threatened species in my area of interest. So I suppose the first place to start is actually how to identify a threatened species. So species in New South Wales can be listed under New South Wales legislation or Commonwealth legislation, or they can be listed under both. And when you're going through the process of actually seeing, do I have a threatened species in my area, it's important to check, whether species are listed under either or both. And there's a few notes on that slide there about what are the type of tools you can use to determine that. So there's some really good databases out there in addition to legislation to determine whether you have these species. It's important to keep in mind that threatened species, there are offences under relevant legislation if you cause any sort of harm to the species themselves or their habitats. So, in the event you've identified a threatened species that's listed under New South Wales legislation, your first point is to conduct a self-assessment and determine yourself whether there is a real potential impact for species. It's important to keep in mind that even if you've got a short-term exploration program, that isn't enough to say that no, you're not going to have an impact on those species. If there is a real potential for impact on those species through the work you're proposing to do, you need to complete an assessment of significance and lodge it with your approval application. That then gets referred to a body called the Biodiversity Conservation Science Directorate, or what we'll shorten to BCS. And on the other side, if you determine there's no real potential impact, that your own self-assessment needs to be factored into your standard drilling approval with the department, including an explanation of why have I determined that I'm not going to impact these species. If that's not acceptable to the department, they can come back to you and ask further questions. But going forward, assuming that you've determined, okay, I've got a threatened species, and I think there's a real potential for impact to that species from the work I'm proposing to undertake, you need to complete this assessment of significance. So what the assessment of significance is going to look like, or the type of matters you should be thinking about when you're going through that, is firstly, what are my species in this area? So you should be obtaining a list of those species. And when you're going through this process, it's important to keep in mind of, not only what species you have, but if there's been any that you've left out of your list of species in the area. As a general rule of thumb, you don't need to consider a particular species if there's been recent work, field-based work, that has been done within your area of interest that has determined there are no species there and their habitat's not there and there's no off-site impacts to those species. You'll also need to consider the impact of your activities on the life cycle of species and the extinction risk. So generally any sort of work that might involve an impact which might reduce a population or its ability to access certain habitat will likely go towards an extinction risk. You'll also need to consider whether your activities are going to increase any sort of key threatening process. A list of key threatening processes are under Schedule 4 of the relevant Act and include matters such like vegetation clearing or more, I suppose, pest species and the like through your activities. And you'll also need to consider the nature of your activities in respect of how that might impact on threatened species habitats, whether that's removal, modification, fragmentation or isolation. It's important to consider during that assessment both occupied and unoccupied habitat because so many threatened species, as their numbers grow, will rely on areas which might be considered unoccupied habitat. So, assuming that you've kind of got all of that under control, when you're actually preparing and ready to finalise your assessment of significance, a few things to keep in mind is, I suppose, throughout those topics, you know, how does all stages of your exploration program go towards that topic? What are your direct and your indirect impacts? What are your on-site and off-site impacts? What's your frequency and duration? And what's your sensitivity of your surrounding environment? In return, what the decision maker who's actually looking at this, or BCS, they will consider such matters like whether your list of species is actually appropriate and comprehensive for your area, including what species you might have omitted from that assessment, whether you've actually considered all sorts of direct and indirect impacts, whether you've considered your life, the full project's life as a whole, as well as the currency of data you've relied upon during this assessment. So beyond New South Wales legislation, if you've got a threatened species that you've identified and it's listed under Commonwealth legislation, kind of similar process in the sense that you start off by doing that sense of assessment, that self-assessment. What is my level of impact? Is it going to be significant, or what does that mean across my project lifestyle? In the approvals process, there's a Commonwealth body that is responsible for the assessment in the Commonwealth space for threatened species. They're actually easier generally to deal with than the state equivalent. When you're going through this process, your first point of call is going to be a pre-referral meeting where you'll discuss your specifics of the exploration program that you're likely to do, the threatened species that you might be encountering, and it should be kept in mind that they can actually ask you any sort of ecological question about your program. So I suppose before going into that meeting, it's important to, I suppose, have a greater understanding of what your project means and what are your impacts. It's a very expensive referral process. That's the current fee, so $6,577 for the referral. So I suppose from my point of view, if you don't need to go down the referral process, it's probably best not to. All right. And to my last third issue is what happens if I have an Aboriginal heritage object in my area of interest. Okay, so the starting point is really due diligence, which you'll find yourself involved in whether you're not sure if Aboriginal objects are likely to be present in the land you're planning on exploring in. If you know those objects might be present but you don't know the level of impact of your activities, or regardless you're in the middle of an approvals process and you're required to assess the level in which your activities might impact on cultural heritage. So a few different ways you can conduct due diligence. There's some great public databases out there such as AIMS, but you can also utilise local knowledge. Landholders and Aboriginal land councils are really good in this regard, as well as previous studies and if there's been any recent site assessments as well. So, in the event that you discover an Aboriginal object in the area of interest you're planning on exploring, you practically have two options. Your first one's to avoid and mitigate it, and it's important if you're selecting, I suppose, that option to make sure you have measures in place to ensure that you will actually avoid and mitigate it. Whether that's going to be measures such as fencing or flagging tape or just walking away in a different direction altogether. To that end, you should also be aware of indirect impacts which might occur through activities and how they might impact any particular objects you've identified. The alternative to that is if you can't avoid interference and you can't avoid interference and you can't change your activities, you must get an Aboriginal Heritage Impact Permit. These should be applied for when your activity is either going to directly or indirectly harm or potentially harm an Aboriginal object through any sort of movement or proposed works you're doing. If you do go down that path, it's a 60-day determination, and if you're not successful, then it's appealed to the Land and Environment Court. When you're going through that application process, you should be consulting with your community, your Aboriginal community, and assessing, the nature of harm. Is it going to be trivial? Is it not? And really practically, what are your proposed alternatives? Your applications for Aboriginal Heritage Impact Permits can be refused if your project design has been unsympathetic, if you haven't done adequate consultation, or where the particular object in your area of interest is of some sort of significance culturally. So I suppose out of that, why are they the two options? So I suppose some context to that is, number one, it's an offence to harm any sort of Aboriginal object under the National Parks and Wildlife Act. There are defences to any sort of prosecution which might come up if you have successfully done your due diligence or if you've gone down the impact permit pathway. And I suppose in the background of all of this, it's important to be aware of your standard condition of title, which will require you to actually ensure that you at all times have measures in place to avoid harm to Aboriginal objects and Aboriginal cultural heritage. And I think probably the most important thing beyond all of this is what does it actually look like if you haven't managed this process properly from an integrity, brand strategy and social responsibility point of view. And that's all for me. Thank you very much.